It gives me great pleasure to welcome you all to the 4th Dr. Anand Prakash Memorial Lecture organized by Multiple Action Research Group. We are privileged that Hon'ble Mr. Justice S Ravindra Bhat, Judge Supreme Court of India, will deliver this lecture today on the topic Evolving Dimensions of Federalism in India. I request Justice Bhat to please come on the dais. And Mr. K.K. Rai, who's the chairman of Multiple Action Research Group, to please come on the dais. I request Mr. K.K. Rai to present and felicitate Justice Bhat. I request Noor Alam, Executive Director Marg, to felicitate Mr. K.K. Rai. The Dr. Anand Memorial Lecture Series has been organized by Marg along with the family of Dr. Anand Prakash to gain insights into the current critical social legal issues. The previous talks have been on issues related to trafficking of women and children, the new labor codes, and the impact of closure on schools on marginalized children. Marg, a non-governmental, non-partisan organization, was set up in 1985 by Dr. Vasudha Dhagambar, a legal scholar, a lawyer, a legal scholar, and a legal activist, to work on social legal issues at the grassroots level. In my mind, there are two very critical contributions of Marg in the field of law and working with marginalized communities. One is the in-depth understanding of displacement of people because of large development projects, in particular dams. And this was done through field-level studies and not through any desk research, but field-level studies talking directly to the affected persons. And this was done in the 1980s and late 1980s and early 1990. And this started the whole issue of of what happened to people when they were displaced from dams. From that whole talking to people, asking them if they knew, they started with the Sardar Sarovar Dam and asking people if they knew what happened, where will they be going, do they know what they're entitled to under the law. And from there came another very big contribution, and what Marg has pioneered in is legal empowerment work, which includes simplifying law and holding workshops and creating a cadre of paralegals in different parts of the country at the grassroots level. And one of the very, very well-known things that Marg has developed as a legal resource material is a series of legal awareness films called Bol Basanto. Even today, which was developed more than 25 years ago. And even today, if we go to any grassroots, any remote area of people working on law and legal literacy, they all ask us, oh, you're associated with Marg, we've seen Bol Basanto. Marg continues to carry on its pioneering work on access to justice and legal empowerment, and is currently working with elected women representatives in panchayats on legal awareness and active citizenship in Uttar Pradesh. In Delhi, Marg has worked alongside the Delhi State Legal Services Authority for over a decade to give legal aid and legal counseling. We look forward to today's lecture by our esteemed speaker with a lot of interest and anticipation, as the topic is very current and pertinent, and it impacts a wide range of socio-economic, legal and political issues. I request Ms. Abha Singhal Joshi, former executive director of Marg, a lawyer, and a very, very active person who does legal awareness work, to come and introduce Dr. Anand Prakash to the gathering.
Thanks, Seema. Good evening. Justice Ravindra Bhat, Mr. K.K. Rai, all the executive director and other board members of Marg, and the distinguished audience. It's my pleasure and privilege to introduce Dr. Anand Prakash, and I should share with you that I had never thought that I would get this privilege, because having known him since 1980, because he happened to be the father of my friends Sameer and Saurabh Prakash, and at that time, we knew people's fathers only vaguely. They were just shadowy presence in our lives, and we were the generation that went all awkward and just would say namaste uncle if we were invited over home for lunch. But that was also the time that we didn't particularly speak of our fathers, illustrious or otherwise. And but when I entered the profession, I realized that, what a presence Dr. Anand Prakash had in the profession itself. Because it just so happened that, everybody knew him, everyone spoke of him so respectfully. And when I saw him as a junior appearing in court, addressing the court, I realized that, one was in the presence of a great legal luminary. So, that's why I'm greatly privileged to speak about him, and also my association with Marg tells me that, what a wonderful association Marg and the Dr. Anand Prakash lecture series have, because like Seema said, Marg's work has been based mostly due to its founder, Dr. Vasudha Dhagambar, on a lot of meticulous research, nuancing of legal subjects. And when we see Dr. Anand Prakash's work, his professional life, and what he brought to the profession and to the world, we realize that there is indeed a close association of Dr. Anand Prakash and Multiple Action Research Group. So a little bit about, I had actually never thought that I would need to prepare for Dr. Anand Prakash, to introduce Dr. Anand Prakash, and I was going to do a very bare-boned introduction. But I happened to come across the full court reference after Dr. Anand Prakash passed away of the Supreme Court of India and of the Delhi High Court, and I was amazed that, at the just the sheer span of his work and his persona. And then it struck me that if a person can seem so relevant 100 years after he came into the world, that person would surely, deserves to be remembered, not just every year, annually at functions, but he really deserves to be remembered in our work and whatever we bring to the table. So just a little bit about, like I said, there was so much to know about Dr. Anand Prakash that so Dr. Anand Prakash was born in 1923 on the 28th of May, and he passed away suddenly in 1996. What I know personally, and what was regularly said in the Supreme Court references, was that he was perfectly hale and hearty. He was following his routines, and he addressed seminars. He attended court on the 10th and 11th of February, and then on the 12th he suddenly passed away due to a cardiac arrest. But be that as it may, it was definitely a great loss to the profession, to the world, to the family. But what he could bring by that time to the profession was just amazing. So just to bullet point his academic achievements, he studied his BA from St. Stephen's College. He then went on to do a graduate and a post-graduation from the London School of Economics, which we all know is, it's really it's a stopping point, at least for our generation. It was really something to be achieved. And after that, he was also, he joined the bar, he was part of the bar in London. And then he came back, and he was very early in 1972. He also was appointed as a senior advocate of the Supreme Court of India. So primarily, what we know of Dr. Anand Prakash is that he was a luminary in the field of labor law. So mostly we heard about that he was in the field of labor law. He was the he was the first name that would come to mind whenever labor law. I remember that when I started my practice, we also engaged him in a few matters. And the amazing thing was that you would see him in the High Court. And since I didn't practice very much in the Supreme Court, I often saw him and heard him in the High Court, and as well as the District Court. And his demeanor, see, what used to happen in the District Court was that when he entered a courtroom, you could sense that the judges almost rose up. The only other person I've heard that about is Mahatma Gandhi. So, his whole this thing, but he was absolutely courteous, absolutely, his demeanor never changed. And I was delighted to see, while reading the Supreme Court references, that that is what everybody has said about him, that he was an absolutely brilliant person, a brilliant lawyer, and yet he was so quiet, humble, sincere to his work, and very, very meticulous when it came to the work, to this thing. So I know that we are aware of him because we were that generation of lawyers who were starstruck by people like Dr. Anand Prakash. And of course, there would be others who read judgments so carefully, like we do, because you read the cause title, then you see who appeared in it, and you even read the petition number to see, how was it placed in that year, when this landmark judgment came. So you would be familiar with what Dr. Anand Prakash brought to the legal world. However, besides this well-known side of him, that he was a really very impressive legal professional, he did many other things. Which I didn't know, that he was quite involved in the freedom movement. He was involved with the Quit India movement. He was part of the Youth Congress. He was the General Secretary of the Delhi Pradesh Congress Committee. So I really wouldn't associate politics with Dr. Anand Prakash as we knew him. Yet, it just shows that, how much a very quiet personality can hold. And the geniality with which he, wore all these hats is something that we could do well to emulate in these times, which we are, to some of us, may seem a little loud and overstated. So, not just that, he was the president, he's been the president of the very prestigious Rotary Club, of the Delhi Management Association, and he wore many other hats. So I absolutely think that Marg is grateful for this privilege, and it's very grateful for the Dr. Anand Prakash Trust to bring to us a speaker like yourself, and to bring together many of us who are batchmates and friends, and to listen to intellectual discourse, which we all really need to increase in this world. Quiet, nuanced, researched, intellectual discourse, I think, is the need of the day. And I'm sure that Dr. Anand Prakash would be very happy if he saw us having this gathering. So thank you very much, all of you.
Thank you, Abha. Now I request Mr. K.K. Rai, Senior Advocate, Chairperson of Multiple Action Research Group, and who's been associated with Multiple Action Research Group for over 30 years. And he was on the as a part of the executive committee ECM when I joined Marg as a employee, and now I am with him in the executive committee. So I request Mr. Rai to introduce the topic and our esteemed speaker.
Honorable Mr. Justice S Ravindra Bhat, Justice Bambani, and distinguished guests. I have to speak about somebody whom I know for the last 40 years, and so therefore it's both a pleasant and a difficult task. But nevertheless, I'll do my part of duty. He would be speaking today on the subject Evolving Dimensions of Federalism in India. Justice Bhat, after practicing law in the Supreme Court of India and Delhi High Court since 1982, was elevated as Judge Delhi High Court on 16/7/2004. Thereafter he became Chief Justice Rajasthan High Court on 5/5/2019 and subsequently joined as Judge Supreme Court of India on 23rd September 2019. He is most eminently suited to speak on the subject because Constitution has been his favorite area. Constitution has been a subject of serious study by Justice Bhat, both as a lawyer and a judge. His judgments are reflective of his deep understanding of the constitutional nuances. In his pursuit of social justice, he has fine-tuned the law in consonance with constitutional values. I'll be just narrating some instances. I'm not getting into details of the judgments which he has delivered, but certain judgments which have impact on society at large. I'm referring to those briefly. Sitting as a High Court judge in Delhi, he allowed public interest to prevail over patent rights of Roche in refusing injunction it sought against generic drug manufacturer Cipla and took a contrarian stand against the prevailing views. So he allowed public interest to prevail in the matter. In order to ensure transparency at the highest level, in CPIO versus Subhash Chandra Agarwal, he made the Chief Justice of India accountable to RTI. Be it disability law, upholding the amendment to SC/ST Prevention of Atrocities Act 1989, securing the conducive environment of the workplace for women, he has craved to ensure protection to persons falling at the bottom of the social structure. Another area of his contribution of interest to Marg is in developing sentencing jurisprudence, particularly his strong emphasis on a sound pre-sentence hearing, emphasizing both on the crime and the criminal. He has emphasized on getting the psychiatric assessment, social environment, and other factors of the accused so that a proper sentencing can be handed out to the person concerned. And just by way of reference, this is Manoj versus State of MP delivered, that is reported as 2023 to SCC 353. And I feel Marg should get into further research on this subject because this is very interesting and it opens new trends in the in criminal justice delivery system. During COVID, he not only participated in relief operations with his wife, he also issued various directions for ensuring equitable vaccination to the masses while sitting as a judge in the Supreme Court. His desire to break free from colonial hangover was further apparent when he issued advisory not to address him as my lord. But old habits die hard, still he's being addressed as my lord by many of us. Marg is proud to welcome you. Just to give a brief introduction about Marg, was founded by Dr. Vasudha Dhagamwar in 1985 to ensure legal empowerment to the marginalized segment of society, especially the women and children. Apart from churning out simple literature on various rights and audio video programs, Marg also works on legal literacy in various states. It also helps the needy who wants access to justice. Vasudha would often comment, it is not enough to pass laws. It is essential to be vigilant to secure their proper enforcement. It is grave error to assume that because law is made, it is automatically known to all, invoked by the sufferers and applied by the government officials. Marg is striving to ensure that law becomes effective for the masses. Now coming to the topic that we are going to discuss today. Federalism has three basic components: political, administrative, and fiscal component based on devolution at various levels of governance. I also see it as a development federalism where local issues are dealt with locally either at the state level or at the panchayat level. This devolution of or decentralization of development has been accelerated after 73 and 74th Amendment to the Constitution with effect from 24th April 1993 and 1st June 1993 respectively. The 73rd Amendment made elaborate provision for Panchayati Raj, making it possible for the panchayats to make plans and garner funds for development. Similarly, the 74th Amendment empowered the municipal democracy. They also made provisions for 33% reservation for women, which neither the parliament nor the assemblies have been able to do for themselves. The devolution of power to the bottom is a welcome example of federalism working on Gandhian principles at grassroots. On the lighter side, federalism is also reflected in real politics. Look at the eagerness to have coalitions at the national level today. The regional forces in remote areas are feeling emboldened and empowered because of that eagerness. I invite now Justice Bhat to speak on the topic.
Thank you, Kameshwar, and I can never regard you as other than Kameshwar Rai, a dear friend of mine. Very good evening to the family members of late Dr. Anand Prakash, Kameshwar, the chairman of Marg, Mr. K.T. Suresh, office bearers and members of the executive of Marg, Ms. Seema Mishra, Ms. Shalini Sinha, Mr. V.N. Rai, Ms. Asha Singh, Mr. Noor Alam. I see many friends, dear friends of mine whom I have known for years and decades. Good evening to you and to all of you ladies and gentlemen. I thank you for the warm welcome and for inviting me to deliver this 4th Dr. Anand Prakash Memorial Lecture. A lot has been said about Dr. Prakash already. A true testament to a life well lived and the impact he had on not only those seated in the audience, but those outside these four walls. I will not repeat the positions that he held and the impact he had on the legal profession, but I personally can recount a couple of observations which I can make having seen him in the court for about 8 or 10 years, and mostly in the High Court. As Abhaji said, he had a presence. There is no doubt about it. He was not very tall. He was of a medium stature, but you could see in the way he spoke. And I regret those days have gone. I mean, many of us always of the older generation lament that those days were good. But in some cases we do feel that, the aggressive advocacy which we see in the courts was lacking in the leaders that we had those days. And Dr. Anand Prakash was one. And I remember another giant again from the labor law field, which is Mr. G.B. Pai. Impeccable in their courtesy, never raising their voices, and almost carrying a conversation with the judge. And from what I can remember, brevity was the other name for the way they advocated their cause. Those days have sadly vanished. Dr. Prakash leaves behind a rich legacy. I am privileged to deliver this lecture on this event of the centenary in his memory. It is commendable for Marg to choose to celebrate his life in the law in this manner. As Mr. Rai said, I am going to speak on the evolving dimensions of federalism in India. The Constitution begins with very tersely, and it describes India shall be a union of states. And that's not it, as the next 394 articles go on to explain in great detail. Unlike many other fundamental features of independent India that were considered radical at the time and were first introduced through the text of the Constitution, the history of federalism dates all the way back to ancient India. I will not dilate too much on it, I will briefly touch upon this. The concept is neither recent nor its history linear. The word federalism itself may not have been a part of the contemporary vocabulary of the time, but historians today who have had the benefit of looking backwards and across time are able to discern various templates in which kingdoms, empires, and territory, long since gone and many forgotten, were organized in federal units or for administrative convenience. Whether it was the Ganasanghs in the north of the Ganges that later became the empires in their own right, like the Mauryan Empire in Magad, or many centuries later, the Mughal revenue system, or even the Vijayanagar kingdom, or presidency towns of the East India Company, Indian history is replete with rich examples of federalism in action. Now, whether these demarcations were an active effort to accommodate diversity or simply strategic to protect new conquests that retained their identity as units, is that the history is often speculative and inconsistent across such a wide cross-section of time and geography. But edicts, textual records under the patronage of rulers themselves, and the accounts of travelers, we have foreign travelers like Fayan, Hunsang, and so on, which form the sources of such history, confirm undoubtedly that the great thought went into these methods of organization and administration employed by rulers. The standout example from ancient India is the empire famed for its rich art, architecture, inscriptions, and historical sources, the Mauryans. What began as a loose-knit empire in 182 BC was centralized heavily by the conquest of the Indo-Gangetic plains. Across successive rulers of the dynasty, the rapidly increasing vastness of the empire was dependent on the loyalty of the commanders that were delegated the responsibility of controlling and administering the new territories. Eventually, the empire came to be divided into 4 provinces within the empire's capital, that is Pataliputra, present-day Patna, which was ruled by the emperor directly. Each of the 4 provinces, Tosali in the east, Ujjain in the west, Suvarnagari in the south, and Takshila in the north, were governed by a royal prince as the king's representative with the aid of council of ministers each. Chanakya's Arthashastra is believed to have shaped the extensive bureaucracy of the empire, with a civil service that covered just about every aspect of governance across each province. The Mahamatta system established in this era is often credited for the inspiration in bureaucratic organization which evolved down the time into the Jagirdari system, the Mansabdari system during the Mughal era, the British Indian Civil Service, and finally the All India services consisting of IAS, IPS, and IFS. Jump to the 1500s, where the Mughal Emperor Akbar improved upon Sher Shah's land revenue system and divided his empire into 12 provinces or subhas, which were designated to be efficient tax revenue collection units. The provinces were governed by subedars who received instructions from their emperor as one link of the complex chain of command that held this empire together, despite its sheer breadth of territory. The subedar was responsible to protect the province both internally and against external aggression and maintain discipline among the armed forces. Akbar's four central departments, finance, war, judiciary, and supply, were replicated at the provincial level as well. By the time Aurangzeb took over, who had himself started as a subedar of a province, there were 21 provinces consolidated under Mughal rule. These were gained either by military conquest or were allowed to retain autonomy if they promised allegiance to the emperor, a promise reinforced by the ties of royal marriage. In British India, the Charter Act of 1833 elevated the Governor General of Bengal as the Governor General of India to consolidate and centralize the administration and make the East India Company's domain the subject of the Crown's trust. However, within 20 years, the Act was amended, divesting the company's powers, and Queen Victoria's proclamation established direct rule, dramatically changing the landscape of federalism in India after the 1855-57 War of Independence. It was realized that decentralization of power had to be the strategy to administer such a vast territory, and the Indian Council Act of 1861 sought to reverse the trend of the 1833 Act. Bombay and Madras were restored their legislative powers, and sharing of federal powers became more fluid. Then we had the Government of India Act 1935 and the Montagu-Chelmsford reforms. These introduced limited self-governance at the provincial levels in an attempt to accommodate rival nationalism of the Muslim League and the Indian National Congress. The Objectives Resolution proposed a highly decentralized federation before independence, wherein the residuary powers were placed with the provinces and the center was to have limited jurisdiction. The question is, how then did we inherit the federal India in its present form? This complete 100-degree volte-face has to be understood in the context of the partition and its aftermath. The division of the Indian subcontinent, both in terms of land and its people, which brought untold trauma resulting in the creation of Pakistan. Haunted by this, the Indian national movement faced further challenges of integrating 560 princely states with the provinces of British India. So we had two Indias. One was a more or less integrated India, which was the British territory, to which the sovereign Indians became the sovereign heirs. And then we had the other 560 territories, which was almost 48% of the country's land, which was split into several sovereignties. And we saw the genius of a leader like Sardar Patel, assisted very ably by V.P. Menon, who brought about this miraculous integration within 2 years. This moment in history is where it was witnessed firsthand the need for a strong central government that could lead development and influence reform while maintaining stability among the federal units. The new federal system had to be protected from threats to its integrity, keeping in mind that each of the hundreds of princely states could not possibly have an equal say in the governance of the country as a whole. Dr. Ambedkar, during the Constituent Assembly debates, said that the draft constitution can be both unitary as well as federal, according to the requirements of time and circumstances. In normal times, it is framed to work as a federal system. But in times of war, it is so designed as to make it work as though it was a unitary system. such a power of converting itself into a unitary state no federation possesses, which remains true even today. Therefore, though it follows a uniquely centralized model, India's federal structure retains a high level of flexibility, which enables its responsiveness in the face of adverse circumstances. The federal units are interdependent rather than independent. The center is often the source of policy but is highly dependent on the states for the actual implementation of the initiatives and programs. This is why the phrase cooperative federalism has been such a catchy characterization. It recognizes that governance in our country relies heavily on intergovernmental collaboration, where the union can overstep in areas of national interest and unity. Interestingly, the word federalism does not find mention at all in the constitution itself. Yet its effect pervades and guides every aspect of governance in India, breathing into the framework of our constitution as it envisioned and prescribes. This has been recognized as a part of the basic structure in one of the Supreme Court judgments, which is called the S R Bommai judgment, which acknowledges that Indian federalism as leaning in favor of a strong center. Indian states find representation only in the Rajya Sabha, designedly called the Council of States. Unlike other federal states, however, the representation is based on population size rather than equal federal subunits. This means that states smaller in size, or those that enjoy special arrangements in the constitution owing to their unique challenges, are able to have limited influence in the Union Parliament, reinforcing the importance and need of constitutional protections that protect them. This unique federal structure was molded after an extensive deliberation by the Constituent Assembly, especially those who represented princely states like Hanumantayya for the princely state of Mysore. They attacked the structure as being too centrally biased to be called a federation. This characterization has led scholars to give India the tag of quasi-federation, administrative federation, organic federation, and so on. Each scholar may choose to label it howsoever they wish, but they all agree on one aspect, that the federal structure is unique, one of a kind, molded with special attention and care to fit the needs of the post-colonial democracy like India. The centralizing tendency of the Constitution is apparent from numerous provisions relating to both executive and legislative distribution. For instance, there is one provision, which is Article 200, by which certain bills passed by the state can be reserved by the governors for consideration of the President, and Article 201, which gives the President a veto. Both of these are without time limit. This was criticized by Granville Austin, a great constitutional scholar, saying that it invalidates the division of powers, for there is no way of overriding such a veto. The misuse of this power was seen most drastically from 1977 to 1985, where some 1,130 bills were said to have been reserved for the President's consideration, with vetoes being rendered almost 12 years later. There have been calls for deletion of such provisions by numerous state governments. Now, coming to legislative power, the Constitution by an elaborate design demarcates the legislative power of Parliament and states. That is, what are the subjects on which Parliament can legislate exclusively? What are the subjects on which the states can legislate without parliamentary intervention or oversight? The principles applicable to resolve, if there is any conflict, even the principles to resolve this conflict have been enunciated. There is another provision called Article 254, which stipulates that when a state law inconsistent with an existing central law, which is possible in some areas, especially the list called the third list or the concurrent list, to the extent that there is inconsistency, the law of the state becomes void. or it is unenforceable. Even though clause 2 states that the state law can prevail if the president assents to it, which is that the central government consents that you can have a separate departure from this law, the Parliament still retain the power to enact a law in relation to that issue, amending, varying, or even repealing the state law. This is one instance where the state can repeal a central law. You have another provision, Article 248, which gives complete residual powers of legislation. Now, what are residual powers? In the central list, you have 96 items. In the state list, you have 66 items. And in the concurrent list, I think you have some 50 odd items. So there can possibly, because no constitution, no mechanism in the world can foresee what is likely to come in the future. So if those instances arise, who has the power? The United States, in the United States, the Constitution, when they made it in 1786, it was left to the states to decide whether they can legislate on it. We have followed an entirely different path. It is the Parliament who has this residuary power. Then there are certain emergency powers under which the Parliament can override and say, we are taking over this subject matter for this period, usually for a year. Sometimes it gets extended. And conversely, there can be situations where, like for instance, we have, some of you lawyers would know, the Urban Land Ceiling Act. Now, this is entirely a state subject, but the Parliament enacted it. Why? Because the states can voluntarily give up that power. So that happened, and there have been many cases where such power has been given to the center. When we come to executive power, the most blatant overlaps, and in cases where supersession of executive powers by the Union occurs in this field, there is one provision which empowers the Union to intervene in state affairs under three well-known circumstances, which is external aggression, internal disturbance, and when the state government is not carried on in accordance with the Constitution. Internal disturbance was substituted by armed rebellion after the emergency in 1975 by the 44th Amendment. There are specifically 8 emergency powers held by the President, which is the central government, in the text of the Constitution, and one of them has never been invoked, which is a financial emergency under Article 360. The Article 352, which can be invoked in the case of external aggression or war, has been invoked only 3 times. Article 356, where the central government retains the power to dismiss state governments and also dissolve state assemblies, was invoked several times, numerous times in fact, before the Constitution was amended in 1978. In fact, there was a report on this, which is called the Sarkaria Commission report, which had recommended certain guidelines about the use of this. Ultimately, this led to the Bommai judgment. These provisions, however, cannot be relied on to arrive at this oversimplification that India is only quasi-federal, or that the powers of states are without a bite. The flexible model of federalism was carefully calibrated to ensure that the Union could respond in emergency situations, that numerous areas of law required uniformity, or when non-negotiable minimum standards the Union had to maintain could be addressed accordingly. There are numerous examples that illustrate lucidly why the center holds the legislative field in certain key subjects. The right to information movement, for instance, culminated in some state enactments. Many states did not enact any law. The Union Parliament passed the RTI Act in supersession of the state's laws in a bid to offer these what are important rights uniformly across the entire country. With regard to fundamental rights too, I can give 2 examples. For instance, we have the right to equal opportunity for public employment, which is available to all citizens. And yet, the state has the power to classify, to make certain laws and impose certain qualifications. And yet there is one area where only Parliament can intervene, which is that in the case of requiring residence requirements in relation to the right to public employment. Why did this constitution say that? Because each state may come out with its own residence requirement. Some states might be liberal, allow other states, people from other states to come and compete, whereas some states might be very restrictive and say it is only people who come from our state who will be allowed to compete in employment in our state in all posts. So it is up to the Union Parliament to prescribe standards, how you can make these laws. Then the second instance is when you have one right, very valuable right, which is the right to move freely and reside and settle anywhere in the country. But there is one restriction on this, which is that to protect local habitats and local residents, which is especially in tribal areas, because we have tribal homelands. Now every other citizen does not have the right to go and settle there. Then another great instance, according to me, is the RTE, or the Right to Education Act. Now, once the Constitution was amended and the right to education became a fundamental right, the question was, how do we implement it? How do we enforce that right? If the states were left to their own devices, we would have had differing rights. And you needed a law to bring that, switch it on, so to say, to activate it. In order to activate that, it is Parliament which intervened and enacted this Right to Education Act, which is also a right. And that we have a uniform right throughout the country for all, which according to me is one of the most valuable rights, the right to be educated. Then we have programs like the Manrega. The center creates the right, the states implement it. The center also funds a large part of it. The approach of the Union is also discernible from other examples. For instance, often when legislative reforms are rolled out by the Union legislature or Parliament, the central government also makes an effort to release model laws and rules upon which the states can rely. This demonstrates an attempt towards adopting a uniform approach without actually dictating a singular outcome. A phrase that finds mention in certain scholarly works is asymmetrical federalism, which resonates more meaningfully with my understanding of the Constitution in its majestic and thoughtful formulation. The constitutional order permits differential treatment of regions and groups based on their unique necessities and based upon their progress and developments, and also having regard to the pluri-ethnic or plurinational country. This covers the autonomy arrangements in the northeastern states, the erstwhile special status of Jammu and Kashmir, administration of tribal areas under the 5th and 6th schedules, and provisions intended to mitigate intra-state inequalities in Andhra Pradesh, Maharashtra, Gujarat and Karnataka. By providing these federal subunits with differential power of self-governance, it allows recognition of their aspirations, their aspirations of what their nation, their India is within the contours of the federal setup of the country. This has often been the result of mobilization along the lines of linguistic, ethnic or socio-cultural groups. Parallels are visible to Canada and its peculiar politics in relation to French-speaking regions and the state's interaction with indigenous communities. In India, these mechanisms are our approach to accommodation of diversity in all its forms, most conspicuously ethno-linguistic basis. Rather than part of the original constitution, many of these provisions are newer addition, reflecting improvisation to respond to evolving changes and challenges within India's vast territory. Chronologically, this began with the provisions relating to Jammu and Kashmir, which were done away with. Separate agreements arrived in relation to Nagaland and Mizoram, which were recorded in different provisions of Article 371 by amendment, and the accession of Sikkim in the early 1970s, which followed suit. There is much to be said about linguistic states, their reorganization, how that too was a part of the federal unit, and how that too was a part of the accommodating impulse, as I might call it. But I think I'm running out of time, so I'll cut it short. I'll come to the issue of local governance. One rich dimension, or one rich saga to the rich chapter to the saga of our evolving pattern, is the introduction of local governance and decentralized federal units through empowerment, constitutional empowerment of municipalities at the district, taluk levels, and the panchayats. Now, we had panchayats in the past, especially in ancient India. We hear of panchayats. We have also heard of panchayats being responsible for administration of law and dispensing justice in some essential forms. But what our panchayat amendments have done is brought governance to the doorstep at the village level and right up to the municipal levels in every state. And the aspiration was to ensure that every citizen ultimately participates in democracy and in the idea of democracy. What is significant about these amendments is that it empowers these bodies to make rules, laws within the framework of state laws entirely. So we have certain taxes which can be imposed by panchayats. Of course, the state has to impose the tax, but the rates and other principles could be worked out by the panchayats. And there are some states which have shown real promise and have shown great results. One of the states, Kerala, for instance, 30% of the budget is earmarked to the panchayats. And there are some panchayats which are actually able to generate excess and surplus. And that surplus results in subsidizing certain essential services within those panchayat territories. Mahatma Gandhi once asked about the India of his dreams, and he stressed on participative development. This is what we have tried to achieve through this amendment. And then we have other provisions, the special features like the fifth and sixth schedule, which cover something like over an overall of 104 districts out of the 700 districts in one way or the other. They are spread over the northeast. They also, you'll find them as a grouping in the central parts of India, in Madhya Pradesh, in Gujarat, in Rajasthan, Chhattisgarh, Jharkhand, and Bihar, and even in Orissa. These schedules are given, these territories and the people are given fair degrees of autonomy in essentially local areas, and state laws cannot be made on those aspects without their own participation. Then the last aspect is the fiscal federalism. The concept of fiscal federalism encompasses various aspects related to government expenditure and revenue at different levels of governance, including the grassroots level of panchayat and municipality. The distribution of expenditure among all levels is an inherent outcome of political federalism, as the act of electing a government loses its significance if that government cannot exercise control over its expenditure. From the beginning, our constitution distinctly defined the roles and responsibilities of both central and state governments concerning expenditure and the instrumentalities required for its implementation. One provision, Article 282, specifically empowers both union the union to provide grants for any public purpose, irrespective of whether that has the power or the states have the power. Now, the significance of this, according to me, is that India's constitution is oriented towards social justice. See, if there are very important programs and policies which need funding within the territory of India, it may be by the center, it may be by the state, and if the center is of the opinion that this should be given that funding, it should be done, and it can be done. The distribution of taxes between union and states, as well as the ratio of division between the states, is further managed by the creation and operation of the Finance Commission. The Constitution also included provisions for sharing revenues generated from certain centrally levied taxes with the states, in addition to providing grants to the states from the consolidated fund. Coming to the present working tax system, one of the most sweeping changes that happened in India's fiscal federal structure was the introduction of the GST through the amendment. Before the implementation of GST, the Union government had exclusive authority to levy indirect taxes, such as interstate sale of goods, service tax, customs and excise duty, and a large number of laws. On the other hand, the states possessed power to levy taxes on intrastate, that is, sales within the state, entertainment tax, purchase tax, levy tax, luxury tax, and most importantly, excise on alcohol. However, with the introduction of the GST regime, all these various indirect taxes were merged and replaced by one tax. Now, this GST, in short, tries to embody one nation, one tax, one nation, one market, so that all economic barriers are overcome, and it seems to be unitary. But the Supreme Court mentioned in one of its recent judgment, which is Mohit Minerals, that the observations made in Bombay highlighting the federal character through the concept of exclusive and equal distribution, the amendment actually granted both parliament and state legislatures simultaneous powers. Now, it would seem that if both parties have the same power, then you can grab as much as you want, which can result in chaos. But also the Constitution made a very beautiful arrangement called a uniquely created one, where neither the union nor the state will have the final say. The decision is taken out of both of them. It is left to the GST Council. And the composition of the GST Council is also very unique. It is comprised of all the states and the representative of the center. Now, you would say that the center would have a smaller voice or a lesser voice. No. The composition is such that 2/3 participation is through the states and 1/3 with the center. And when it comes to a decision, there has to be a 3/4 majority, which means that there has to be a unanimity, almost near unanimity, in the kind of taxes and what items are to be taxed and who is to do it. So the pooling of sovereignty, as it is called, the finance minister then said, this is a case where the powers are pooled and given to a third body. We have come out with a unique arrangement where neither party has the exclusive power, but both have the power, but the principles are evolved in a very clear-cut manner to avoid any friction and conflict. We have not yet come across conflict, but possibly there could be some conflict later, but for which hopefully the resolution will be in the courts. As an audience, I hope that your takeaway from this address is that the criticism that India's federal structure is unitary or simply quasi-federal is misplaced. Undoubtedly, there are provisions which give a larger role to the center to step in, but equally there are provisions which empower the states to protect their geographic and contextual interests. The carefully calibrated design of our Constitution with all its nuts and bolts is truly magnificent in foresight. Consider, for instance, the constitutional status of independent institutions like the Election Commission of India. Just visualize for a moment It avoids all the horrors and divisions of a extremely contested elections, like the one which happened in 2000 and more recently in 2019 in the United States, where every state has the power to make its own election laws and certify the results through their legislatures, and where the states can say when can the voter vote and where he can. So there are many states which insisted that regardless of COVID, people have to come to the election and cast their votes in the election booth. So that kind of chaos is avoided. For 17 years, this country has witnessed governance by way of coalition governments. And 10 years there has been 10 years there have been governments which have depended on other outside political support. For these terms, the government of the day had to rely on support of diverse political forces. This brings its own dynamic opportunities and challenges. So the often political parties have ruled in the state domain without forming the government at the center. Occasion has risen in the recent past that when such parties have come to power at the center, with their experience informs the policy making approach. In short, the ability to bargain is directly impacted by the political compact and the shape of the polity. Therefore, in theory, what may seem to be very unitary in its formulation is actually dependent on the states, the parties that govern them, and the cooperation among them. The challenges to our federal structure, if any, will be along these fault lines. The dialogue between the different elements of the polity ensures a richness which is missed in academic and judicial discourse, which tend to focus on events. The dynamic element of a vibrant political dialogue is essential to maintain this shifting balance between the powers of the center and the state, adding to the richness of our diversity. Thank you.
Thank you very much, Justice Bhat. You gave us a very in-depth understanding on the topic, not only in-depth, but a very, very easily understood, which is very pertinent to Marg. And I think this is the first time I have to be embarrassed to say that I understood the GST really well. So, and also while hearing the lecture, I kept thinking, because now I'll be able to, when I have to do a legal awareness session, and on constitution and on the role and responsibility of the different organs of the state, I'll be able to explain it much better. And believe me, people ask very, very difficult questions. And I think I'm much better equipped to do that. So I'm really very happy with the lecture. Just a small memento on behalf of Marg for Justice Bhat. I know. Now I would like to request Saurabh Prakash, advocate, and the son of Dr. Anand Prakash, and who also has a very, very old association with Marg. He's also on our general body, to come and give a vote of thanks.
Thank you, Seema. I've had occasion to appear before Justice Bhat several times when he was in the Delhi High Court. I don't think I've appeared before him, before the Supreme Court yet. I still have some time, sir, perhaps. He was always a one of the most polite and humble judges, and I think that must have come across to all of you also today. Always, I've had one occasion I can recall when there was a particularly recalcitrant client who would not listen to the suggestions that had fallen from your lordship. And I was admonished by you, but I never went away from your court feeling like I had been slighted. It was always, I knew that my client was playing on technicalities and was not looking at the ethics of the action that they had taken. Nevertheless, it was my duty to present his case before you. It was not decided by you, but the fate of the case remained the same before another bench. So I heard Justice Bhat outside the Delhi High Court about a year and a half ago at a talk he gave on trailblazing women in law. And that was such a thought-provoking talk. I had no idea that the Indian Constituent Assembly had so many leading lawyers of the time and had played such an important role in the drafting of the Constitution. Unfortunately, all the conversation around the drafting of the Constitution revolves around one or two persons. I wish greater attention were paid and the role of many other persons, especially of lady lawyers of that time, acknowledged too, which frankly, sir, I've never heard anybody else address. That was the first time. And so, sir, this is the centenary of my father's birth. And Justice Rai, Mr. Rai was kind enough to, perhaps Justice Rai to, in due course. He was kind enough to request you, and you were kind enough to agree to deliver this talk, which has been another thought-provoking talk. And as Seema said, she's probably going to fib this as her knowledge of GST and other matters, but I would request you to also study it before you do that. So, sir, and also the fact you mentioned about the Panchayati Raj, and my wife has had occasion when she was working with NGOs to work very closely with women in Panchayati Raj systems. And I can see your interest and deep knowledge of history, especially Indian history, which was the subject of choice of my father. And had he been alive, perhaps he would have detained you today and had a further discussion with you. So, sir, thank you very much for this talk on behalf of the entire Prakash family, especially my mother, who cannot be here due to her health. But she was delighted to have you speak at this centenary occasion. So, sir, thank you very much, and good day to everyone. Thank you.
Thank you everyone for your presence, and we end this function here today. Thank you.